Hello students and welcome to the lecture. So students, as we know that we are covering the emergency provisions and basically these are the topics we have scheduled for the discussion under this particular series, like starting with the introduction part, thereafter the national emergency, the parliamentary approval and the duration, the president's rule, the financial emergency, and the criticism of the emergency provision. All right, these are the topics we have scheduled for the discussion. Out of this, basically we had finished the introduction part and we have been discussing upon the national emergency. Okay, so that is the picture we have created so far all together. So we will continue from where we had left in the previous lecture. I hope that you have revised the previous one in the well enough manner before you have come for this lecture. As many times I have told you, that is for your own benefit. So if you are doing this on the regular basis, the thing will be much more easier for you in the examination. All right, so let's start from where we had left in the previous lecture. Okay, so basically, in the previous lecture, we had discussed all these points like while a proclamation of national emergency is in operation, the state is freed from the restrictions imposed by the Article 19 because Article 19 got suspended. In other words, the state can make any law or can take any executive action which is abridging or taking away the six fundamental rights which are guaranteed by the Article 19. Thereafter, we had discussed that any such law or executive action cannot be challenged on the ground that they are inconsistent with the six fundamental rights which are guaranteed by the Article 19. All right. When the national emergency ceases to operate, Article 19 automatically revises and comes into force. Any law made during emergency to the extent of inconsistency with Article 19 cease to have effects. These are the 5 points we had discussed in the previous lectures. Now, let's move ahead of. All right. Thereafter, next point is, however, no remedy lies for anything done during the emergency even after the emergency expires. What does it mean? It means that suppose if government has brought XYZ law during the emergency, all right, when the emergency expire or revoke, still there is no remedy lies for anything for the XYZ. It means the XYZ provisions will be in effect even after the emergency revokes. All right. What does it mean? This means that the legislative and the executive actions taken during the emergency cannot be challenged even after the emergency ceases to operate. Okay. It means that the state or the government is allowed to take the legislative actions and to take the executive actions. And whatever they did during the emergency, that could not be challenged in any court. All right. But thereafter, there is a thing which came after the 44th Amendment Act of 1970. Okay. All these provisions were priorly available in the Article 358 of the Indian Constitution. All right. But some changes were introduced and made by the 44th Amendment Act of 1970, which is basically restricted the scope of Article 358 in two ways. Or what are these two ways? First way is, firstly, the six fundamental rights under the Article 19 can be suspended only when the national emergency is declared on the ground of war or external aggression and not on the ground of armed rebellion. What does it mean? It means that, as we had, you can say, discussed in the previous slides in the previous lectures, that whenever the emergency in the force, the fundamental rights will be revoked. All right. So what this provision said, 44th Amendment Act of 1978, what did they say? They say that the six fundamental rights which are guaranteed by the Article 19 can be suspended. Yes, they could be suspended, but only when national emergency has been declared on the ground of war or the external aggression only. If the national emergency is declared on the grounds of armed rebellion, which was previously known as the internal disturbances. All right. Then the rights could not be suspended. The first thing was revoked. Thereafter, secondly, only those laws which are related with the emergency are protected from being challenged and not other laws. Okay. It means that the laws which were formulated during the emergency or to control the situation due to which the emergency is to be implemented. Only those particular laws are exempted from the emergency proclamation, not other laws. It means that other laws will be put under the condition of judicial review. All right. Also, the executive action taken only under such a law is protected. It means that suppose there are two legislative passed. First is L1, second is L2. All right. It means the L1 is related with the national emergency causes. But L2 is not related with the national emergency causes. Then what will happen? Only the protection will be granted protection will only be granted for the first one. It means that national emergency causes. Okay. No protection will be granted for the laws which are not related with the national emergency causes. Secondary thing is that the executive actions which are generally taken for the implementation of the legislation. So, if the executive action has been taken in order for the L1, it means that the legislature which is related with the national emergency causes, only that executive will be protected. But if the executive action is related with the L2, then no such permission would be granted, or you can say protection will be granted. All right. So, 44th Amendment Act basically made the provision that only the legislatures and the executive actions which were taken in order in relation with the national emergency causes, only those will be protected. And other legislature and the executive actions which are not related with the L2 and not related with the emergency causes, those are not protected under the immunity shield. Okay. So that's were introduced after the 44th Amendment Act of 1978. Now let's move ahead. Thereafter, after the Article 358, another article we have 359. Okay. Article 359 stands for the suspension of the other fundamental rights. Like which other fundamental rights will be suspended? Article 359 authorizes the President of India to suspend the right to move any court for the enforcement of the fundamental rights during the national emergency. Okay. Which means Article 32, when it's a matter of Supreme Court. And Article 226, when the matter is for the High Court. All right. Only these two cases, the person could move to the courts in enforcement for the enforcement of the fundamental rights. So these provisions could be deleted as per the Article 359 by the executive orders of the President. All right. This means that under Article 359, the fundamental rights as such are not suspended, but only their enforcement. It means that no rights will be revoked, but they would not be enforced as they enforced during the normal times. Got it? The said rights are theoretically alive, but the right to seek remedy is suspended. It means that on book or on paper, the rights are granted to the people. The people could exercise them. But if the government has launched some, or you can say provisions and the legislatures which are suspending those rights, then basically seeking remedy for them is not approved. All right. Thereafter, the suspension of enforcement relates to only those fundamental rights that are specified in the presidential orders. It means that whatsoever fundamental rights are provided by the Constitution of India to the people of India, only suspension of enforcement will be granted to those rights which were mentioned in the presidential orders. Okay? Thereafter, further, the suspension could be the, or you can say could be for the period during the operation of emergency or for a shorter period as mentioned in the order. All right. And the suspension order may be extended to the whole or any part of the country. Okay. It should be laid before each house of parliament for approval. Okay. It means that in front of Lok Sabha, as well as in front of the Rajya Sabha. Okay. Thereafter, while a presidential order is in force, the state can make any law or can take any executive action abridging or taking away the specified fundamental rights. Okay. It means that if the presidential orders specify the fundamental rights, which could be revoked, then the state or the government can make any law or can take any executive action to abridge or taking away the said rights, or you can say the specified fundamental rights. All right. Any such law or executive action cannot be challenged on the ground that they are inconsistent with the specified fundamental rights. All right. When the order ceases to operate, it means that presidential order was revoked. Any law so made to the extent of the inconsistency with the specified fundamental rights ceases to have effect. It means that once the presidential order will be revoked, whatever the actions, whether in the legislative form, in the executive form, the state has taken, those actions, and you can say broad inconsistency with respect to the specified fundamental rights will ceases to have any effect. All right. Thereafter, but no remedy lies for anything done during the operation of the order, even after the order ceases to operate. It means that after the order, suppose the order was passed in January and continued till July, for example, for 6 months. What does it mean? It means that after the July, no action or the legislature, the government could brought to abridge or taking away the specified fundamental rights in the presidential orders. But whatsoever executive actions and whatsoever legislative actions the government has taken during the time period of 6 months, they could not be challenged. Okay. It means that what has done during the operation of the order, okay, even after the ceases to operate, this could not be challenged anyhow. Okay. Thereafter, this means that the legislative and the executive actions taken during the operation of the order cannot be challenged even after the order expires. That is what I had told you right now. Come forward. The 44th Amendment Act of 1978 restricted the scope of Article 359 in the two ways. It means that this amendment not only restrict the Article 358 but also the Article 359. What does it mean? Firstly, the President cannot suspend the right to move to the court for the enforcement of fundamental rights guaranteed by Article 20 and Article 21. That is what we had also seen in the previous lecture. Like two said articles, Article 20, Article 21. Article 20 is right against detention. Okay. And Article 21 is right to life and personal liberty. These two articles could not be suspended. Okay. It means that the President could not revoke the power of a person to move to the court for the enforcement of these two articles. All the other fundamental rights article could be suspended. Even the right to move to the court regarding those articles could be suspended, but not in the matter of right against detention and right to life and the personal liberty. All right. In other words, the right to protection in respect of the conviction of offenses, Article 20, and the right to live life and the personal liberty, Article 21, remain enforceable even during the emergency. The same thing I had told you right now. Secondly, only those laws which are related with the emergency are protected from being challenged, and not other laws and the executive action taken only under such a law is protected. Okay. Now, what is the difference or distinction between the Article 358 and the Article 359? The differences between the Article 358 and the 359 can be summarized as follows. First, Article 358 is confined to the fundamental rights under Article 19 only, whereas Article 359 extends to all those fundamental rights whose enforcement is suspended by the presidential orders. All right. It means that Article 358 only related with the Article 19 of the Indian Constitution, while the Article 359 extends to all those fundamental rights whose enforcement would be suspended by the mentioning under the presidential orders. First thing. Second, Article 358 automatically suspends the fundamental rights under Article 19 as soon as the emergency is declared. Okay. It means that once the emergency will declare, suppose the emergency is declared on 21st January, for example, only. Okay. So the moment the emergency will declare, immediately the fundamental rights under 19 will be suspended automatically. No special executive or legislative orders are required for this. All right. On the other hand, Article 359 does not automatically suspend any fundamental right. only empowers the president to suspend the enforcement of the specified fundamental rights. What does it mean? It means that for the suspension of other rights or the other fundamental rights, a proper executive or the legislative order must be required from the presidential orders. All right. Thereafter, Article 358 operates only in the case of external emergency. Okay. That is when the emergency is declared on the grounds of war or the external aggregation. Okay. And not in the case of internal emergency. Therefore, when the emergency is declared on the ground of armed rebellion. Okay. Article 359, on the other hand, operates in case of both the external emergency as well as the internal emergency. External or the internal. Got it? Thereafter, Article 358 suspends the fundamental right until Article 19 for the entire duration of emergency, while the Article 359 suspends the enforcement of fundamental rights for a period specified by the President, which may either be the entire duration of the emergency or a shorter period. So you could say, suppose if the emergency was implemented in January, so it could continue up to July, okay? Because up to the 6 months, the emergency could be continued, then it's required the repassing or the continuation, okay? So basically, the Article 358 could suspend the Article 19 for the entire duration. But Article 359 could only be do this only for specified duration. Not for the entire duration, but only for the specified duration. And this could be the proper 6 months, or suppose, as per the orders, the rights only suspended under Article 359 from January to March. What is the duration? Three months is the duration. Okay. Thereafter, Article 358 extends to the entire country, whereas Article 359 may extend to the entire country or any part of it. Okay. It means that it is not necessary that the presidential orders made under the Article 359 may extend to the entire country or part of it. Thereafter, Article 358 suspends the Article 19 completely, while the Article 359 does not empower the suspension of the enforcement of Article 20 and 90. Okay, I had told in the previous lecture that basically from Article 14 to Article 32, we have the, you could say, fundamental rights. All right. So the Article 358 having the power to suspend the Article 19 completely. But Article 359 could suspend the other articles exception for the Article 20 and Article 21 because they could not be suspended even during the emergencies in the force. Thereafter, Article 358 enables the state to make any law or take any executive action inconsistent with the fundamental rights. Under the Article 19, while the Article 359 enables the state to make any law or take any executive action inconsistent with those fundamental rights whose enforcement is suspended by the presidential order, not by automatically. Got it? Thereafter, there is also a similarity between the Article 358 and the Article 359. Okay? What is the similarity? Both provide immunity from challenge to only those laws which are related with the emergency and not other laws. It means that the immunity from being judged by the judicial review, okay, is only available for the emergency related actions, whether they are in the legislative form and in the executive form. Not other laws could be hampered. Okay. Thereafter, also, the executive action taken only under such a law is protected by the both. Okay. It means that if the executive action was taken regarding the laws which having the relevancy with the emergency, only those actions could be protected. All right. Thereafter, declaration made so far. This type of emergency has been proclaimed 3 times so far. Like first happened in the 1962, then 1971, then the 1975. It means that 3 times the emergency was introduced in the India. The first proclamation of national emergency was issued in October 1962 on account of the Chinese aggression in the NAFA, northeastern frontier of agency. Now it is known as the Arunachal Pradesh. Okay. Previously, 1962, that was known as the NAFA and was in force till January 1968. Okay. Thereafter, hence, a fresh proclamation of national emergency was made in December 1971 in the wake of attack by the Pakistan, because in 1971 basically we had the Indo-Pak war. Okay. In 1962 basically we have the Indo-Sino war. Okay. Even when this emergency was in operation, a third proclamation of national emergency was made in June 1975. Okay. Both the second and the third proclamations were revoked in the March 1977. Okay. Why? Now, what is written down here? It is written down that when already the 1971 emergency was in the force, we had declared the second emergency in the 1975. Okay. So, what is the reason behind it? Remember that government introduced 1971 emergency for war or external aggregation. The 1975 was declared on the basis of internal disturbance. Okay, so that's why they were, you can say, introduced side by side, and both were revoked in March 1977. Okay, so students, basically in this lecture we have finished till here. In the next lecture we will continue from here. Till then, just revise all the facts and figures whatsoever we have discussed in this lecture and keep yourself ready for the next lecture. With this note, let's end this lecture and thank you.